Starts.
Yes. Esteemed and erudite CA Hariram Agarwal, the resource person of this great evening, my good friend and regional council member CA Sundarajan, senior members, friends, very good evening to all of you. When I am present here this evening to perform the pleasurable and privileged duty of extending a warm and hearty welcome to the resource person and other members of this great profession, I am filled with extreme elation, emotion, and excitement for many reasons. One, that this meeting will edge in my thoughts always as having been the occasion to interact with my colleagues in a forum like this in the capacity of chairman of SIRC before I demit my office as chairman in the ensuing regional council meeting scheduled for day after tomorrow. Therefore, it is an emotional occasion for me. The second, the last 356 days since my assuming the office of chairman on 24th February, a blessed opportunity bestowed upon me. I had endeavored and endeared myself to be in the mainstream of service to our members and students and repay what little I can to the profession. She has given me a stature and a significant place in the society. Therefore, it is an occasion of extreme elation. Thirdly, I had received the warmth and affection from the entire professional fraternity, east to west, north to south, from all directions. Therefore, I am excited. I am speechless and trying to locate appropriate words to express my sincere thanks and gratitude to my colleagues in this regional council, in the profession, my well-wishers, the people around me, in the administration, and to everyone who have made my tenure satisfying and memorable. It is in this respect, this meeting had offered me an opportunity to record my inner feelings and also an opportunity to wish all of you and through you convey to those members who could not participate my grateful thanks and offer my best wishes and greetings for happy days ahead, both in professional and personal life, with enrichment and enlightenment. With this, I deem it my privilege and a pleasure to welcome our learned speaker of the day, C.A. Hariram Agarwal, who is part of the team in the helm of affairs in the our esteemed regional council, Eastern India Regional Council. He has been kind enough to accept our request to deliver a lecture on one of the most important areas pertaining to our professional esteem, and that is ethical values, which is intertwined in our professional service. I also express my warm welcome to my council colleagues here, Sundarajan sir, for an enlightening session of this evening. My gratitude to the members is infinite, whose cooperation is the backbone for the success of entire program of SIRC. It is their show of support even during the trying times of pandemic situation that gave us strength that have kept our activities vibrant. I am very happy to have the participation of members to this evening meeting. I heartily welcome all the members to this program, even though the tax audit reporting due date is today. In spite of this due date, I think the good number of members attending for this great program. I look forward to a continued support to my successors. Let me add to highlight the importance of the subject of discussion today. ICAI has issued advisories to all the programs organizing unit to embed the topic on ethics in the structure of the schedule of the programs, which shows the significance and value ICAI attached to this concept. I'm happy to state here that SIRC has conducted programs at regular intervals on the subject during the year, and all the programs were well received. What is ethical values and why it should be an integral part of everyone's life? How one can follow ethical values under different circumstances? What benefit that will accrue by being ethical in our action? What would be the result if ethical values are not followed? There are many questions that linger in the minds of everyone, from common man to intellectual like us. Our speaker, C. Hariram Agarwal, is here to enlighten us on some of the aspects which are often asked, and his reasoning during the course of his address will further enhance our perspective on ethics and its observance. When we talk about ethics, two things need to be taken into account. One, whether you are in pursuit of principle or prosperity. One cannot go together with other. When you are in principle, it may be possible that you may harvest prosperity other than what you deserve for upholding the principle. If you are high on prosperity, then it would be possible that you may shun away your principles. Here, placed here, the code of ethics is everyone's behavioral approach. Let us continue to the man of principles, and prosperity will follow. Let this program further tune our thoughts in this direction. With these words, I once again thank the resource person for being with us today and welcome him and the other participants to this great evening program. I assure that my service to the profession will continue forever, and I will look forward for other opportunity to interact with my professional colleagues. Thank you so much for this great opportunity. Now I request C.A. Sundarajan, Regional Council member, to formally introduce the speaker of this great evening. Over to you.
Namaskaram, Chairman sir. Namaskaram, Agarwal sir, and namaskaram to the members present in this visual program. This is a great evening, and as said by our chairman, we have enjoyed with him, and really wonderful programs have been organized in this year, and we thank you for all that. I think I can take the lead, being the one of the person in the screen, to thank you personally on behalf of the members. Thank you, sir. Thank you so much, sir. Welcome, Sri Hariram Agarwal, sir. And his profile is that CA Hariram Agarwal is a BCom Hans from St. Xavier's College, LLB, FCA, FCS, Visa of ICAI and Insolvency Professional. In current year, Sir is Treasurer EIRC of ICAI, heading 5 committees as chairman and 6 committees as vice chairman, and member of 11 other subcommittees in EIRC Council. Mr. Agarwal, sir, was a member of the Ethical Standard Board of the Institute of Chartered Accountants of India, New Delhi, for the year 13-14. He is also acting as arbitrator for NSE and BSE and independent director at the board of 2 public limited companies. Sir is a regular speaker and has spoken in more than 100 occasions for programs like workshops, seminars, study circle meetings on different subjects, inclusive of corporate law, direct tax, drafting of will, ethical standards, etc. From time to time, he is engaged with a large number of social and other organizations, and also the moderator of Professional Interaction Google Group. Sir, we welcome you, sir. We have also organized a lot of programs, as said by Jalpati sir, in the southern region. Yeah, we welcome, sir. Now the forum is yours, sir. You can take up, sir. Thank you, sir. Thank you, Jalpati sir.
Thank you, sir. Thank you, Chairman sir, CAK Jalpati sir, Chairman sir. And we have seen a good number of programs from SIRC from time to time. Despite these odd situations, SIRC has done very nice, and it is one of the best regional councils award winners council. And RCM SIRC CA Sundarajan sir, Secretary CA Pannaraj S sir, other RCMs and members of SIRC, I welcome to all of you to this program on FAQ on ethical values. Friends, I'm really grateful for the SIRC for giving me the opportunity to share my views on ethical values. Friends, in recent past, on being a council member, there was a frequent queries from different persons day and night, every day, other day, that what will be this answer for this query, what will be this query. So based on those queries, I have sorted out around hundreds of questions, and those 100 questions have been listed out here, and I'll be discussing one by one the questions and their answers so that it is well understood by all of you. So that is the basically my plan. Friends, what does ethics means? Ethics means moral belief and rules about right and wrong. The word ethic is derived from the Greek word ethos, that is character, taken together, and moras is the customs. So taken, these two words define how individuals choose to interact with one another. Oxford Dictionary defines the word ethics as moral principles that govern a person's behavior or the conducting of the activity. Friends, thus ethic is about choices. It signifies how people act in order to make the right choice and produce good behavior. Ethics may be termed as philosophical ethics, ethical theory, or moral philosophy. Ethics, professional ethics is a branch of ethics which encompasses the personal, organizational, and corporate standards of behavior expected of professionals. Professionals and those working in acknowledged professions exercise specialist knowledge and skill. Professionals are capable of making judgments, applying their skills, and reaching informed decisions in situations that the general public cannot, because they have not received the relevant training. Therefore, it is the utmost important that the professionals are governed by a set of ethical standards. Ethics are important for chartered accountants because accounting profession requires as much ethical know-how as anything else. They make clear the concept of right and wrong in given set of circumstances. They help the professional accountants to build personal fortitude to make a right decision. Ethical behavior is one of the essential personal skill that professional accountants must possess. An accountant can never succeed in his field if he ignores ethics. It is very essential to define ethics within the accounting profession. It is extremely important for accounting professionals to be ethical in their practices due to very nature of their profession. The nature of accountants' work puts them in a special position of trust in relation to their clients, employers, general public who rely on their professional judgment. So this is the what a background of ethics and ethical values. So my screen is visible to all of you. Friends, my screen is visible to all of you, sir.
Yes, sir. It is visible, sir.
Visible. Okay, thank you.
Yes, sir.
So what's on the first
So-
page only, so you can just run through the slides. So
Yeah, okay, then I'm
putting the slideshow.
yes, sir. Thank you. So this is what ethical standards board of ICAI. ICAI has made a specific board to control, regulate, and update these ethical standards under the ESB, that is Ethical Standard Board of India. And I'm coming out with these frequently asked questions on ethical values. And these questions, as our time permits, I will discuss question and give you pause to think the right answer for that, and thereafter I myself will be answering those questions, so that a concept of ethical values, ethics, will be clear in your mind, sir. Thank you, sir. So This is EQ, ethical quotient. So this EQ is called ethical quotient. So first being whether a professional accountant in public practice means practice may pay or receive a referral fees or commission. So this is the very frequent question, whether a professional accountant in practice may pay or receive a referral fees or commission. So this is a very common practice that somebody is referring us our professional work. So can we share referral fees or commission with him? Answer is yes. As per clause 3 of part 1 of first schedule in volume 2 of the Code of Ethics, it is not prohibited for a member in practice to charge referral fees, being the fees obtained by a member in practice from another member in practice in relation to referring a client to him. So now it is clear that if a chartered accountant is referring a professional work to his fellow chartered accountant in practice and he is charging a referral fees, it is very much allowable under class 3 of part 1 of the first schedule. Now, can a member in practice render management consultancy and other services? Can a member in practice render management consultancy and other services? Answer is yes. What type of management consultancy can serve? The areas covered under the management consultancy and other services have been summarized by the council, and that has been covered under this paragraph. So those management consultancy services which has been specifically approved by the council can be practiced. Whether a member in practice is permitted to undertake the management of NRI funds, whether a member in practice can do the management of NRI funds, that is the catchwords. No, not permitted to undertake such assignment, as the same is not covered under management consultancy and other services permitted to be rendered by the practicing member of the institute. Therefore, not permitted. Next is, can a chartered accountant provide portfolio management service, that is PMS, as a part of CA profession? You must be knowing the PMS, concept of PMS. So assuming that, the question is, can a CA provide PMS as part of CA practice? Answer is no. The explanation to class 19 of the definition of management consultancy and other services expressly bars the activities of broking, underwriting, and portfolio management. Therefore, a CA cannot undertake PMS services. Whether a CA in practice is required to obtain any trade license for practicing? Trade license for practicing, is it required? No. From the standpoint of ICAI, it is not required to obtain the trade license for practicing as a professional. The COP is the only requirement to practice as a chartered accountant, but to comply with the local authority law, if local authority specifies to obtain trade license, that is required to be obtained by CA in practice. As regards in West Bengal, where from I belong to, it is requirement to obtain trade license. So the we chartered accountant in West Bengal possess trade license for practicing as a chartered accountant, but it is not the requirement of ICAI. Can a chartered accountant in practice work as a collection agent or recovery agent? Can a CA in practice work as collection agent or recovery agent? No. A CA in practice cannot work as a collection agent. However, he can act as a recovery consultant, not agent. Recovery consultant as provided in clause 25 of management consultancy and other services as appearing in appendix 3. So in appendix 3, the list is given and it is appearing in clause 25 that cannot work as collection agent. Can a member holding COP is entitled to own agricultural land and continue agricultural activity? So here are two concepts: owning agricultural land and continuing agricultural activity. So what can be the answer? Answer is yes. Member holding COP can own and hold agricultural land and continue agricultural activity. So this is well within the permission. What are the fundamental principles which a professional accountant is required to comply? Fundamental principles of professional chartered accountant. So these are the basic 5 fundamental principles. These are integrity, objectivity, professional competence and due care, confidentiality, professional behavior. So these are the 5 fundamental principles. Reading out once again: integrity, objectivity, professional competence and due care, confidentiality, and professional behavior. These are the fundamental principles based on which a professional accountant or practicing chartered accountant is required to comply with. Now, whether the statutory auditors consisting of 10 or more members can conduct the branch audit of the same company. Let me illustrate it. Suppose company A Limited is being audited by C and Company Chartered Accountant Firm, and C and Company Chartered Accountant Firm is statutory auditor of this A Limited, which consists C and Company consists of say 11 partners. So can C and Company audit the A Limited, its branch office? The answer is normally not, but exceptionally yes. So under what circumstances it is normally yes or no? Let us understand it. And what is the purpose behind this restricting a firm of chartered accountant exceeding 10 members to audit the branch audit of a same company? The council has decided certain self-regulatory measures in order to ensure healthy growth of profession and the equitable flow of professional work among the members. Right. One of the recommendations of this nature is that branch audits of a company should not be conducted by its statutory auditors consisting of 10 or more members, but should be conducted by the local firms of auditors consisting of less than 10 members. So the branch audit of A Limited can be conducted by the local firms of chartered accountant where the branch is situated, in which less than 10 chartered accountants are there. This should not be understood to mean any restriction on the right of any statutory auditor to have access over branch accounts conferred under Companies Act. This restriction may not apply in the following cases. Number 1, where the accounting records of the branches are maintained at the head office of the respective companies, and where significant operation of an undertaking or a company are carried out at its branch office. So under these two circumstances, these restrictions may not apply to a CA firm. Whether there is a minimum audit fees to be charged by the members of the institute. So many times we come to here say that this is the minimum fees, it must be charged or that cannot be charged, something like that. So what this ethical issues says about this? Answer is no. There is no mandatory minimum audit fees required to be charged by the members of the institute. It is the prerogative of the member himself or herself or the firm itself who determine that what will be the audit fees charges or what will be the payout by the client of their services provided for audit services. Can a member in practice be a sleeping partner in family business concern? Member in practice, sleeping partner in family business. Can you do that? The answer may be yes or answer may be no, but subject to certain conditions. So what are these? When yes is there, a member in practice can be sleeping partner in family business concern, provided he takes prior and specific permission from the council in terms of regulation 109A. He will, however, not be entitled to do attached functions, right? So sleeping partner in family business and practice by attesting functions simultaneously not allowed. Then what is allowed? So you can be a sleeping partner in family business, but prior permission is required, plus you cannot do attached functions. So these two are these riders of being a sleeping partner in family business. Whether the members are required to intimate his website address to the institute? No, members are not statutorily required to intimate the website address to the institute. However, the website has to comply with guidelines issued by the institute and which is updated from time to time. So that guideline has to be complied with, and the intimation of website is not mandatory, but it is always good if you have some to inform or update your data along with your website address. Can a member act as tax auditor and internal auditor together? Tax auditor and internal auditor of an entity together? Answer is no. Council has decided that an internal auditor of an assessee, whether working with the organization or an independently practicing CA, being an individual or a firm of CA, cannot be appointed as his tax auditor, right? So internal auditor and tax auditor cannot go together. It has to be gone by side by two different firms of CA or chartered accountants side by side. Whether a member holding COP who is an employee in a CA firm can be enrolled as GST practitioner. Mark the question properly. Member holding COP who is an employee of CA firm. So this is the catchword, whether he or she can be enrolled as GST practitioner or not. Yes, he can enroll as GST practitioner as this is not an attached function, subject to contractual obligation, if any, with the employer. Whether it is permissible for a member to mention himself as a GST consultant, whether it is permissible for a member to mention himself as GST consultant? Answer is no. In terms of provisions of clause 7 of part 1 of first schedule, it is not permissible for a member to mention himself as GST consultant. Can a chartered accountant in practice allow any person to practice in his name as chartered accountant? So can I, as a chartered accountant in practice, allow any other person to practice in my name as chartered accountant? Answer is no. Clause 1 part 1 of first schedule to the CA Act prohibits a CA in practice to allow any person to practice in his name as CA unless such person is also a chartered accountant in practice and is in partnership with or employed by him. So anybody else who is my partner can practice under the name of my firm HR Agarwal and Associates, otherwise not. Whether practicing CA can be a partner or designated partner in a LLP which is not doing professional work but is in the commercial activities. The similar question was placed earlier based on the same line, little bit different. Whether a practicing CA can be a partner or designated partner in LLP which is not doing professional work but is in the commercial activity? No. As per paragraph clause 4 of part 1 of a schedule, a practicing chartered accountant cannot be a partner or designated partner in a LLP which is not doing professional work but is in commercial activities. Can a member in practice hold kiosk for providing certain government services in areas where online access is not available? Suppose a CA in practice is practicing in such area where certain government services are not available. So he can support, he can help by providing online access to these government services. Can he do that? A member in practice can provide such services through kiosk if the services provided are professional services of a practicing CA permitted under that. So it has to be within that framework only. Whether a member in practice can act as a mediator. Yes, a member in practice can act as a mediator, since acting as mediator would be deemed to be covered within the meaning of arbitrator, which is inter alia permitted as per regulation 191 of the CA regulation. Whether a member in service can represent before income tax authorities on behalf of other employees or colleagues of the company. Whether a member in service, suppose one CA who is in service, can he represent before the IT authorities on behalf of other employees or colleagues of the company? A member in service can appear as tax representative before tax authorities on behalf of employer only, but not on behalf of employees or colleagues. Whether a member in practice can hold custom broker's license under section 146 of the Customs Act. In terms of provision of code, it is not permissible for members in practice to hold customs broker's license under section 146 of the Customs Act, read with Customs Broker Licensing Regulation 2013. Can a member in practice print QR, that is quick response code, on his visiting cards, facilitating easy access to informations? With the development of technology, we must be knowing that in some visiting cards we are seeing the QR code printed on the visiting card. So with the help of this QR, just scanning this QR code, all the data can be seen or stored instantly. So can a member in practice print QR code on his visiting card? So the answer is yes. Printing of QR code in the visiting card is permissible, provided it does not contain information that is not otherwise permissible to be printed on a visiting card. Meaning thereby, so data contained in this QR code should be only the data permitted to be printed on the visiting card. Can a member in practice render management consultancy and other services? Can a member in practice render management consultancy and other services? The answer is yes. However, the areas covered under the management consultancy and other services have been summarized by the council. So it is the similar question which was raised earlier: management consultancy and other services. Whether a CA firm can be registered with the institute as limited liability partnership. Can a CA firm be registered with the institute as a LLP? The answer is very simple: yes. Why the CA Amendment Act 2011 definition of firm has been amended to include LLP as defined in LLP Act. whether a member holding certificate of practice will be deemed to be in practice even if he is not serving any client. I'm just repeating the question, whether a member holding COP will be deemed to be in practice, holding COP will be deemed to be in practice even if he is not serving client. Suppose I am holding COP, right, but not serving any client. It means I'm not serving any client. So will I be permitted to be in practice? Yes, a member is deemed to be in practice not only when he's actually engaged in the practice of accountancy, but also when he offers to render accountancy services, whether or not he in fact does so. Right? A member is deemed to be in practice not only when he is actually engaged in the practice of accountancy, but also when he offers to render accountancy services, whether or not he is in fact does so. The next question is whether a messaging application, SMS, which we know as SMS, whether SMS can be used by a member in practice to send messages to make people aware about their new practice and mention the services provided therein. Once he has started his new practice, he wants to know whether he can forward SMS and that he has started his practice, and also mention the services that I am providing these services, whether he can send SMS for that. This is very frequent questions. The answer is no. It is not permissible to use SMS to make people aware about their new practice and mention the services provided therein. So he cannot send the message SMS. Similar is the SMS is similar is the with this WhatsApp message also. Same terminology analogy will apply over that also, because that is also a messaging application. Can a CAP allow any person to practice in his name as chartered accountant? Answer is no. Can a member share profits with the widow of his deceased partner? This is a very common question. Can a member share profits with the widow of deceased partner? There is a partnership firm, and where 3-4 partners are there. Say one of the partner deceased or expired due to whatever reason. So the other members or other partners in the firm, whether they can share the profits with the widow of the deceased partner. Is it permissible? Yes, it is permissible, but with certain restrictions. So we will see what are the restrictions contained therein. When there are 2 or more partners and one of them dies, the widow of the deceased partner can continue to receive a share of the profit of the firm. A legal representative, say widow of a deceased partner, would be entitled to share the profits only where the partnership agreement contains a provision that on the death of the partner, his widow or legal representative would be entitled to such payment by way of sharing of fees or otherwise for the specified period. Right? So there are, how many riders are there? Number one is that yes, partners can share, or the widow can continue to receive share of profits of the firm. Legal representative in the name of widow would be entitled to share the profits. So the rider is that partnership agreement contains a provision that on the death of the partner, his widow or legal representative would be entitled to such payments by way of sharing of fees or otherwise for the specified period. So the specified word period is also a catch over here. So so the next time when we are preparing our partnership deed, or if we want to safeguard, protect widow of any of the partner, so please check your partnership deed. If that partnership does not contain this clause, and you wish that the widow of a partner should share of profit, so suitable clause should be mentioned or included therein, that such and such sharing of fees for a specified period has to be specified, and it depends on the understanding of both the partners. Whether a member in practice can respond to tenders, advertisements, and circulars? Answer is yes. It is permitted under clause 6 of part 1 of the first schedule. This should be read with council guidelines dated 7th April 2016, which are appearing at Appendix J of Volume 2 of Code of Ethics, in which the guidelines has been provided for participating in tenders, advertisement, and circulars. So the meaning thereby, it is permitted under clause 6, but the guideline has to be followed to participate in tenders. Can a CA in practice solicit professional work by making roving inquiries? The meaning thereby, that CA in practice ask for the professional work by asking unlimited number of persons for favoring by providing this professional work. It is not permitted for a member to address letters, emails, or circulars to persons who are likely to require services of chartered accountant. It would tantamount to advertisement under clause 6 of part 1 of the first schedule. So he cannot make a roving inquiry for getting the professional work. If he does so, that is professional misconduct pursuant to clause 6 of part 1 of the first schedule of the Act. Can a CA in practice accept original professional work emanating from the client introduced to him by another member? Mark the language of this question. Can a CA in practice accept original professional work? Original professional work means the work which is just generated or just started. Say the one company was incorporated just now, and the first auditor is required to be appointed. So similar nature of work is called original professional work emanating from the client, introduced to him by another member. If this has been introduced by another member, so can a CA in practice accept? The answer is no. Why? Why no? Clause 6, as appearing in volume 2 of the first schedule, prescribes that a member should not accept the original work emanating from a client introduced to him by another member. If any professional work of such client comes to him directly, it should be his duty to ask the client that he should come through the other member dealing generally with his original work. So that is the ethics should be followed. Can a CA in practice firm of chartered accountants post the particulars of himself itself on a website? Yes. The council has approved the detailed guideline for posting the particulars on website by CA in practice and firms of chartered accountant in practice. Whether website of a CA can provide a link to the website of ICAI, its regional council, branches, website of government department, regulatory authorities, and other professional bodies. Whether, suppose I'm getting my website prepared. So whether a website of myself or my firm's website can provide a link to the website of ICAI, its regional council say SIRC, EIRC, WIRC, CIRC, and IRC, and any of the 168 branches of ICAI, or the websites of government, say MCA, income tax, or other department, or regulatory authorities and other professionals. Can I provide that in my website? Answer is yes. It is permitted that website may provide link to the website of ICAI, its regional council, branches, chapters, and also to the website of government department, regulatory authorities, and other professional bodies. So yes, we can provide it. Can a member put up his photograph on the website? Can a member put up his photograph on his website? Yes. Council guideline for advertisement appearing in volume 2 of code provides that display of passport style photograph is permitted. Means publishing of photograph is permitted provided that photograph is passport style photograph. Can a member or firm of chartered accountant print vision and values behind the visiting card? So one may have vision and values. So can I print those vision and values behind the visiting cards of mine? The answer is no. Since such printing of vision and values behind the visiting card may result in solicitation and violation of the provisions of clause 6 of the first schedule to the act, right? So printing of vision and values behind visiting card is not allowed, because in the view of the council, it may result in solicitation and violation of the provision of clause 6. Can a CA in practice give the date of setting up the practice or date of establishment on the letterheads and other professional documents, etc.? Suppose my firm was started way back in 27 years back. So can I give the date of setting up of the practice or establishment of the firm on the letterhead, other professional documents, etc.? No. According to clause 7 of part 1 of the first schedule, date of setting up of the firm on the letterheads and the professional document should not be entitled, should to be mentioned on it. However, in the website, the year of establishment can be given. Whether a CA in practice can use the designation corporate liar? Can the designation corporate liar be used? Whether a CA in practice can use the designation corporate liar? No. A CA in practice is not permitted to use the designation corporate lawyer. Simple. Can a chartered accountant practice firm give advertisement in press? Say I want to give an advertisement in press and media or newspaper, whatever it is. So can I give? No. However, the member in practice may advertise the services, setting out the services provided by him or his firm and particulars of his firm through a write-up subject to advertisement guidelines issued by the council. So even if you circulate the write-up, advertisement guidelines issued by the council has to be abided by. If a member is a partner in more than one firm, it is permissible to print the names of all the firms on visiting cards, letterheads, stationery, etc. Say I Hari Ram Agarwal is a partner in firm A Limited, A and Company, B and Company, C and Company. Say, I'm member in part. I'm being a member partner in say 3 firms. Is it permissible to print the name of all the 3? A and Company, B and Company, C and Company on visiting card, letterhead, stationery, etc. of mine? Yes. There is no violation under clause 7 of the part 1 of schedule if I get printed on this name of all the firms in which I am a partner. Whether members of the institute can use common CA logo. Whether members of the institute can use common CA logo. The answer is yes. What it is? The common CA logo can be used by all the members whether in practice or not. Encapsulating the current beliefs, attitudes and value of the profession, the CA logo seeks to enhance the identity of the members. The logo consists of the letters CA with a tick mark upside down inside a rounded rectangle with white background. So you can use the logo of the institute with certain restrictions. Tick mark upside down, rounded rectangle, white background. These are the preconditions for getting this printed. Whether a member may put a CA logo on his website on the same background color as that of website? The answer is, as per logo guideline issued by ICAI, in the CA logo, the background color of logo has to be white. Suppose background color of my website is purple. So can I have printed purple background logo or not? No. It is to be complied with accordingly, irrespective of the background color of website. Can a CA in practice use or fix a monogram of the institute on any column, wall located inside the office or in a professional document? No. In view of the council direction under clause 7, CA in practice is not permitted to use or fix a monogram of the institute on any column or wall located inside the office or any professional document. Whether the office of the chartered accountant is permitted to go in for ISO certification or other similar certifications. Whether the office of a CA is permitted to go in for ISO certification. Yes, there is no bar for a member to go in for ISO certification or other similar certifications. However, the member cannot use the expressions like ISO certified on his professional documents or visiting cards or letterheads or signboards, etc. So that has to be kept in mind. Next, if a member has passed any additional course of ICAI, is he permitted to print such qualification on visiting card, letterhead and other stationery? Answer is very simple. It is not permissible for a member to mention the name of the certificate course of the ICAI cleared by him. However, wherever diploma is awarded by the ICAI, the same can be mentioned on the visiting card, letterhead, other stationery, etc. For example, DISA within bracket ICAI. This is what we can use it. DISA ICAI. Whether the public notice published in the newspaper by a chartered accountant individually or jointly with an advocate in respect of acquisition of land by their client is permitted. Whether public notice published in the newspaper by a CA individually or jointly with an advocate in respect of acquisition of land by their client is permitted. So the nature of this question is such that I being an advocate or chartered accountant publish public document we are publishing in newspaper, say that such and such person is my client, he is willing to acquire such and such land. If anybody has any stake or interest therein, please come out within such and such date and put your claims. So that sort of public notice published in the newspaper by a CA, is it permissible or not permissible? Yes, in terms of the provisions of Council Guideline for Advertisement appearing in Volume 2 of Code of Ethics, public notice published in the newspaper in respect of acquirement of land by their client is permissible. Just example I've given, that my client is acquiring such and such land. If anybody has got any concern, interest in that property or land, can come out. So that sort of advertisement is permissible according to the guidelines for advertisement. Whether the members in practice can print their photograph on their visiting card. Many members are putting their photographs on the visiting card. So whether a member in practice can print, the answer is no. It is not permissible for the members in practice to print their photograph on their visiting cards. What should be the sequence of designation while a member also uses the region as doctor along with CA? Doctor as well as CA. The member is free to use the designation doctor along with CA in whichever sequence or order he wants to. We have got our President ICAI, who is having both these designation, doctor and CA. So it is his prerogative, it is his choice. He is free to use the designation doctor, CA in any sequence or order he wants. For your kind information, Dr. CA Dr. Devashish Mitra is writing CA first, then doctor, then Devashish Mitra. So that is CA Devashish Mitra. So that is the biggest example what our President ICAI is using. Which designations can be mentioned by a member in practice impaneled as insolvency professional on his visiting card, letterhead, other communication? A member in practice impaneled as insolvency professional can mention insolvency professional on his visiting cards, letterheads, and other communication, as this is recognized by the central government in terms of clause 7 first schedule. Mention of any other nomenclatures, designations, including membership of any IPA, is not allowed. Meeting deliberation. Whether a chartered accountant in practice can accept a position as auditor previously held by another chartered accountant without first communicating with him in writing. Whether a chartered accountant in practice can accept position as auditor previously held by another chartered accountant without first communicating with him in writing? No. A CA in practice cannot accept a position as auditor previously held by another CA without first communicating with him in writing. It will be in violation of clause 8 of first schedule of the Act. So whenever we are getting an assignment, an auditor must communicate with the previous auditor first, according to clause 8. If he is not communicating, that is professional misconduct. Whether a CA can accept appointment as an auditor after sending communication to the previous auditor through registered post without acknowledgement due. Whether a CA can accept appointment as an auditor after sending communication. Means just simply sending the communication is sufficient. No, a CA cannot accept an appointment as an auditor after sending communication to the previous auditor through registered post without acknowledgement due, as this may tantamount to professional misconduct, meaning thereby that even registered post with acknowledgement due is must. Whether communication with the previous auditor as contemplated in clause 8 is permissible while messaging application, that is SMS? No. Communication via SMS or WhatsApp message say is not permissible as an evidence of communication being sent as required under clause 8 of the first schedule. Whether a chartered accountant who is appointed as tax auditor for conducting a special audit under the Income Tax Act by the IT authorities is required to communicate with his statutory auditor. Whether a CA appointed as tax auditor for conducting a special audit under IT Act by IT authorities is required to communicate with the statutory auditor, because statutory auditor is appointed by the company, by its shareholders, by its directors. So whether he under IT Act it is appointed by IT authorities. So is it required by a chartered accountant to communicate first? Yes. Council direction mentioned under clause 8 prescribes that it would be a healthy practice if a tax auditor appointed by conducting special audit under IT Act communicates with the members who has conducted the statutory or tax audit. So statutory audit, tax audit may be conducted by one or more than one person. So it is desirable and healthy practice to communicate with these persons by the person who has been appointed by IT authorities under IT Act. Whether communication with previous auditor is necessary in case of appointment as statutory auditor of a nationalized and other banks. We see that at the time of allocation of allotment of branch audits, the time period is very short, and this question arises every year, and a good number of our members are in confusion or dilemma that whether it is necessary to communicate with previous auditor under such circumstances. The answer is yes. According to clause 8, it is equally applicable in case of nationalized and other banks, and also to government agencies. So communication must be made. Whether communication by the incoming auditor is mandatory with the previous auditor in respect of various audit assignments like concurrent audit, revenue audit, tax audit, special audit, or any other audit. Yes, the requirement for communicating with the previous auditor would apply to all the audits, whether it is statutory, tax audit, GST audit, internal audit, concurrent audit, or any other kind of audit. Council has laid down detailed guidelines in this regard under clause 8, first schedule to the Act, appearing in Code of Ethics. Whether member in practice is allowed to become whole-time director of a company. Member in practice and whole-time director in a company. Can we do both the things together? Answer is no. Members are not allowed to become whole-time director of a company generally. However, a member in practice may become MD or whole-time director of a body corporate subject to the council guideline of corporate form of practice. Council guidelines of corporate form of practice under Appendix 3 must be referred, must be taken care of before accepting whole-time director. So in company, a practicing chartered accountant cannot, but he can accept only as a whole-time director of a body corporate subject to the council guideline of corporate form of practice. If it is corporate form of practice, whole-time director is permissible, otherwise not. Whether the member in practice can be director simpliciter of a company. Director simpliciter of a company. Now, what is director simpliciter? A member in practice is permitted generally to be a director simpliciter of a company, provided he is not a managing director or whole-time director and is required only in the board meeting of the company, not paid any remuneration except for attending such meetings. Meaning thereby that CA in practice is generally permitted, means not required to take permission to be appointed as director simpliciter, not managing or whole-time director, and he is getting board meeting or sitting fees only and not the remuneration. So he can do that, and also no specific permission of the council is required in this matter. Can a CA working in a CA firm? CA working in a CA firm hold a COP? Yes. CA working in a firm of CA can hold certificate of practice. However, he is not entitled to do any attest function. CA working in a firm of CA can hold COP, but he is not entitled to do, with effect from 2005, any attest function. Whether a member in practice owning intellectual property rights of domain name sell these domain names to some entity for earning royalty on the same. Whether a member in practice owning intellectual property rights of domain names sell the domain names of some entity for earning royalty of the same, can he do that? No. Since the activity of selling domain name for earning royalty would amount to other business or occupation, which is prohibited under clause 11 of part 1 of first schedule. So he cannot do the activity of selling domain names for earning royalty. Whether a member who is statutory auditor of a company can let out property owned by HUF to the said company. Member who is statutory auditor of the company can let out property owned by his HUF to the auditee company. HUF is treated as separate entity for the purposes of the assessment under ICAI. However, since the individual member and the Karta of HUF are practically the same person, such transaction should be avoided, not restricted, but avoided from an independence perspective. Whether a member in practice is generally permitted to write script story for a movie, to write script or story for a movie, the answer is a script or story for a movie may be based on book written by a member in practice. However, merely writing a script or story for a movie would not fall within the general permission provided under Appendix 9 of CA regulation. Such a member would require prior and specific permission of the council in this regard. Whether a member in practice can also practice simultaneously as an actuary, meaning thereby, I am a chartered accountant in practice. Can I also practice simultaneously as an actuary. I am practicing as a CA. Can I also practice as an actuary? No. The members in practice have not been permitted by the council to practice as actuary simultaneously. Simultaneously, he cannot do. COP भी hold करेगा और actuary भी hold करेगा, practice करेगा. दोनों practice एक साथ not allowed. Whether a member in practice can become financial advisor and receive fees or commission from financial institutions such as mutual fund, insurance companies, NBFCs, etc. Whether a member in practice can become financial advisor and receive fees commission from FIs. The answer is no. It is not permissible for a member in practice to become financial advisor and receive fees or commission from financial institutions. Whether a firm of CA can undertake the assignment of management consultancy services of a company where a partner of the firm is director simpliciter. Yes. So the question was whether a CA firm can undertake the assignment of management consultancy of a company where a partner of the firm is director simpliciter. Answer is yes. It is permissible for a firm of CA to undertake the assignment of management consultancy where a partner of the firm is director simpliciter. Whether a member in practice is permitted to be an athlete or play tournaments simultaneously along with hold issue. Since the activity of being an athlete or playing tournament is not covered under the Appendix 9 of the regulations, a member in practice may only be an amateur athlete. However, it is not permissible for him to be a professional athlete. COP and professional athlete cannot go together. Simply means either no COP and professional athlete or COP and amateur athletes. Whether a member of the institute shall be deemed to be guilty of professional misconduct if he does not supply the information called for or does not comply with the requirement asked for by the institute. Whether a member of the institute shall be deemed to be guilty of professional misconduct if does not supply information asked by the institute. Yes. As per clause 2 of part 3 of a schedule, a member of the institute shall be deemed to be guilty of professional misconduct if he does not supply the information called for or does not comply with the requirements asked for by the institutes. So it will be a professional misconduct. Can a CA in practice disclose information required in the course of his professional engagement? Meaning thereby, I am a chartered accountant practice and I am having some professional engagement and working in a professional engagement. So in the course of this professional engagement, can I disclose information acquired herein to anybody else? Answer is no. As per clause 1 of part 1 of second schedule of the Act, a CA in practice shall be deemed to be guilty of professional misconduct if he discloses information required in the course of his professional engagement to any person other than his client so engaging him without the consent of his client or otherwise than as required by law for the time being in force. Suppose we have got some professional engagement conducting these professional assignments, came out with certain informations. Some government officials or departments in the process of investigation or their other purposes, can a CA provide information to them? In that case, that is permissible, but without the consent of client or otherwise not compulsory, cannot share the information or detail or information procured during the course of the audit. Whether an auditor is required to provide to the client or to main auditor of HO of the same enterprise access to his audit working papers. I'm just repeating, whether an auditor is required to provide to the client or main auditor of the HO access to his audit working papers. Answer is no. Working papers are the property of an auditor. An auditor is not required to provide the client access to his audit working papers. The main auditors of an enterprise do not have right of access to the audit working papers of the branch auditors. The auditor may, at his discretion in cases considered appropriate by him, make portions of or the extracts from his working paper available to the client. Now it's a very simple question, whether joint auditors can whether joint auditors can demand the working papers of one another. One client X Limited is there, Y and Associates and Z and Associates, two joint auditors are there. So while conducting or after conducting this audit of X Limited, whether the proprietor partners of Y Associates and Z Associates can demand the working papers of each other? The answer is no. Working papers are the property of the auditor. Therefore, no joint auditor can demand the working papers of the other auditor. Whether a joint auditor will be responsible for the work done by other joint auditor. The same example I am carrying. X Limited is a limited company for which Y and Associates and Z and Associates is auditing their accounts as a joint auditor. So whether Y Associates will be responsible for the work done by Z and Associates and vice versa, whether that can be done. The council direction under paragraph of one of second schedule of the Act prescribes that in respect of the audit work divided among the joint auditors, each joint auditor is responsible only for the work allocated to him, including proper execution of the audit procedures. However, on the other hand, all the joint auditors are jointly and severally responsible for the work which is not interested divided among the auditors. So simply speaking, if joint auditors work division is done, work allotted separately amongst themselves, so only the auditor to whom the particular audit work has been assigned will be responsible only for the work allocated to him. And when there is not interested divided work, so what will happen there? All joint holders are jointly and severally responsible for that work. So simple logic. Whether the CA who is appointed as liquidator of a company can do the audit of a or that particular company. CA appointed as liquidator of the company A Limited say. So whether Y and Associates can do the audit of that company? The answer is no. Clause 4 of the second schedule to the Act and regulations framed thereunder may be referred, under which it is mentioned that CA appointed as liquidator of a company cannot do audit of the company. Whether a chartered accountant can be guilty of professional misconduct when if he accepts the auditorship of a college if he is working as part-time lecturer in that college. Meaning thereby Mr. A is there who is working as part-time lecturer in that college. He is a chartered accountant and accepts the auditorship of that college, whether it is permissible or guilty of misconduct. Another part is accept the auditorship of a trust where his partner is either an employee or a trustee of the trust. Answer is yes. CA will be guilty of professional misconduct in both the above referred circumstances. What are the both circumstances? Accept the auditorship of a college working as a part-time lecturer in that college, or auditorship of trust where his partner is either employee or trustee of the trust. Can a CA accept the assignment of audit of a company in which he is a director? Simply no. In cases where the member is a director of a company, the financial statement of which are to be audited and or opinion is to be expressed, he should not undertake such job and or express opinion on the financial statement of that particular company. So assignment of audit by company in which director, no. Whether a member can accept audit of a company where the relative of the member is director in that company. Member, say Hariram Agrawal, can accept audit of a company where my relative is director in the company. Answer is no. Since a member is not entitled for appointment as an auditor of the company as per section 141 3F of the Company Act 13, if his relative is a director or is in the employment of the company as a director or the key managerial person, the member is not eligible for appointment. Whether the fee received from limited review quarterly audit of the same undertaking or company under the listing regulations should be included in the fees received for carrying out the statutory audit of the same undertaking company, while comparing the same with the fee from permissible non-audit services. Let me analyze it, whether the fees provided from limited review or quarterly review of the same company should be included in the fees received for carrying out a statutory audit of the undertaking. The exemptions of the general rule contained in Chapter 9 of the Council General Guideline mention audit under any other statute, and the limited or quarterly review would not be included in the same, as these are done in the same statute. Hence, limited review, quarterly audit may be deemed to be included in the statutory audit. Whether fees from professional services rendered from the issuance of accountants reports under Income Tax Act 1961, that is 3CEB report, should be considered under exemption provision paragraph 9.2. considering that such services are of the nature of assurance services, whether the fees from professional services rendered for the issuance of accountant's report under IT Act 3, that is 3 CEB. Certification work required to be done by the statutory auditors is exempt from the general rule. Accordingly, the provisions of this chapter will not apply to a certification which can be done by a CA in practice. Whether a statutory auditor can accept the system audit of the same entity, whether a statutory auditor can accept the system audit of the same entity, meaning thereby, say, Mr. X, a chartered accountant, is statutory auditor of a company. Whether Mr. X can accept the system audit of that particular company? Yes. The statutory auditor can accept the assignment of a system audit of the same entity, provided it did not involve any scrutiny review of the financial data and information. So the statutory auditor can accept the assignment of a system audit. Say who are having, for example, DISA, Diploma in Information System Audit. So that particular chartered accountant can perform this system audit of the particular entity, provided it did not involve any scrutiny review of the financial data and information. Whether a chartered accountant is qualified to be appointed as a statutory auditor of one associate company when he is the internal auditor of another fellow associate company. Whether a CA is qualified to be appointed as a statutory auditor of one associate, say statutory auditor of a company, when he is internal auditor of another fellow associate company, B company. Yes, except internal audit of the fellow associate company, because there is no holding subsidiary relations between such companies, and therefore there is no violation of provision contained in section 2030. Whether a member in practice will be liable if he fails to disclose a material fact known to him which is not disclosed in the financial statement, but disclosure of which is necessary to make the financial statement not misleading. The sentence is, or rather question is long but very simple. Member in practice liable if he fails to disclose material fact known to him, not disclosed in financial statement, but disclosure of such is necessary to make the financial statement not misleading. Meaning thereby, if you are not mentioning the same, the financial statement will be misleading. Yes, as per clause 5, a member in practice shall be deemed to be guilty of professional misconduct if he fails to disclose a material fact known to him which is not disclosed in a financial statement, but disclosure of which is necessary to make the financial statement not misleading. Whether a member in practice will be liable if he fails to report a material misstatement known to him to appear in financial statement which he is concerned in a professional capacity. Whether a member in practice liable if he fails to report material misstatement to appear in financial statement with which he is under professional capacity. Yes, as per clause 6, part 1 of second schedule, member in practice shall be deemed to be guilty of professional misconduct if he fails to report a material misstatement known to him to appear in a financial statement with which he is concerned in a professional capacity. The next question is whether a member in practice will be liable if he is grossly negligent in the conduct of the professional duties. Whether a member in practice will be liable if he is grossly negligent in the conduct of his professional duties? The answer is simple, yes. As per clause 7 of part 1 of second schedule, a member in practice will be deemed to be guilty of professional misconduct if he does not exercise due diligence or is grossly negligent in the conduct of his professional duties. Whether a member in practice will be liable if he fails to invite attention to any material departure from the generally accepted procedure of audit applicable to the circumstances. Whether a member in practice will be liable if he fails to invite attention to any material departure from the generally accepted procedure of audit applicable to the circumstances. The answer is yes. As per clause 9 of part 1 of second schedule to the act, member in practice shall be deemed to be guilty of professional misconduct if he fails to invite attention to material departure from the generally accepted procedure of audit applicable to the circumstances. Can a chartered accountant receive professional fees in advance, partly or in full? Suppose I have been assigned one work. Can I ask or take or get or receive professional fees in advance, whether it is partly or in full? Can I do that? Yes. As such, there is no bar in the act or in the CA regulation as well as code of ethics in taking the fees in advance. A CA can take very much the advance or part payment of fees. Whether a member of the institute will be liable if he contravenes any of the provision of the act or regulation or the guidelines issued by the council? The answer is very much simple. Answer is yes. As per clause 1 of the second schedule to the CA Act, a member in practice shall be deemed to be guilty of professional misconduct if he contravenes any of the provisions of the Act or regulations made thereunder or any guidelines issued by the council. Is there any ceiling on the number of tax audit assignments that can be taken up by a member in practice? Yes. In exercise of the powers conferred under clause 1 of the second schedule of the Council of the Institute, Council General Guideline, Chapter 6, which specifies that a member of the institute in practice shall be deemed to be guilty of professional misconduct if he accepts in a financial year more than a specified number of tax audit assignment under section 44AB of the Income Tax Act 1961. The number specified for tax audit is 60. Here I would like to mention that suppose there are 2 or 3 or more than that number of partners are there. So the firm can accept the number of tax audit, that is 60 into number of partners in the firm. So if there are 2 partners, the firm can accept 60 into 2, that is 120 audits. If it is proprietorship or individual name, then it is 61. Whether the audits conducted under section 44AD, ADA, AE of the Income Tax Act shall be taken into account for the purpose of counting the specified number of tax audit assignments? The answer is no. As per Chapter 6 of the Council General Guidelines, audits conducted under section 44AD, 44ADA and 44AE of the IT Act shall not be taken into account for the purpose of reckoning the specified number of tax audit assignment, that is 60, as we have discussed in just last question. Whether there is any ceiling on the number of company audit, that is statutory audit assignment, that can be taken up by a member in practice or a firm of chartered accountant? Yes. In view of the Chapter 8 of the Council General Guideline, member in practice or a proprietorship firm can accept 30 audit assignments, whether in respect of private companies or other companies, with the exception of one-person companies and dormant companies. Meaning thereby, one-person company and dormant companies are out of the purview of counting of 30. That is 30 plus one-person company and dormant companies. What is the status of a chartered accountant who is salaried employee of a CA in practice or a firm of such chartered accountant? What is the status of CA who is salaried employee of CA firm or a CA? An associate or fellow of the institute who is a salaried employee of the CA in practice or a firm of CA shall, notwithstanding its such employment, be deemed to be in practice for the limited purpose of the training of article assistants. He may hold a COP, but he is not entitled to attest function with effect from 1/4/2005. This part of the question already discussed earlier also. Can a member publish a change in the partnership or change in the address of the practice and telephone number? Suppose a chartered account practice is having change in address of his practice, or change in the telephone number, or change in partnership. Can that chartered accountant or firm of chartered accountant publish such changes? Yes. A member can publish a change in partnership or change in the address of practice and telephone numbers. Such announcements should be made limited to a bare statement of facts and consideration given to the appropriateness of the area of distribution of the newspaper or magazine and the number of insertions. So these are the certain restrictions within the purview of that can publish the changes in the partnership, address, telephone numbers, etc. Whether there are any known your client KYC norms to be followed by the member in practice, whether a CA in practice conduct or maintain KYC norms for all the client. Yes, a member in practice are required to follow KYC. Hello. A member in practice are required to follow KYC norms, which are mandatory with effect from 1st January 2017. These are applicable for all attest functions. Attest functions for this purpose includes services pertaining to audit. So whosoever our audit clients, we are supposed to follow KYC norms. Review agreed upon procedures and compilation of financial statements. The KYC norms may be assessed in paragraph number R320.3 A6 of volume 1 of Code of Ethics. Whether it is permissible for a member to mention himself as GST consultant? No. In terms of the provision of clause 7 of part 1 of first schedule to the Act, it is not permissible for a member to mention himself as GST consultant. Whether two or more members can collectively have joint training session for their clients on GST and share the fees collected from the clients thereof. Suppose Mr. A B, C, 3 chartered accountants. They make a pact among themselves that, okay, let us give a training to our clients on the topic, say GST. My clients, their accountants are less conversant, yours is too, and yours is also. So we should make a session, training session for them, and charge a fees for attending that training session, and whether we can share the fees collected from the clients thereof. Can we do that? Yes, it is permissible for 2 or more members can collectively have joint training session for their clients on GST and share the fees collected from the clients thereof. So friends, mark here that their clients, session for their clients. So session for clients is permissible, otherwise it is not permissible. Say if we do it for other persons who are not our clients, charge fees, share the fees, so that is not permissible. Whether member in service is permitted to take ERI, e-return registration in his her name. Whether a member in service is permitted to take ERI in his or her name. A member in service may take e-return registration if it is not conflict with the employment obligations. A member in service may take e-return registration if it is not conflict with the employment obligations. However, a return cannot be certified by the members. Whether partner of a firm of a CA doing audit of an insurance company can accept the assignment of surveyor of the said company, meaning thereby my firm is a CA firm doing audit of an insurance company. Can I, one of the partner, accept the assignment of surveyor of the said company? The answer is no. It is not permitted for a partner of a firm of chartered accountants doing audit of an insurance company to accept the assignment of surveyor of the said company, as it is likely to impact independence of as auditor. So you are doing audit, you are taking assignment of this as surveyor from the same company. So where is the independence of auditor? Independence of auditor is not there, so it is not permitted. Whether a member in practice can hold a custom broker license under 146 of the Customs Act? Answer is no. In terms of the provision of code, it is not permissible for the member in practice to hold license under section 146 of the Custom Act 1962, read with Custom Broker Licensing Regulation 13. What are the safeguards available to a professional accountant in public practice in respect of custody of client assets? By repeating, what are the safeguards available to a chartered accountant in practice in respect of custody of client assets? So let us understand the question thoroughly. As per section 350 of volume 1 of code, a professional accountant in public practice entrusted with money or other assets belonging to others shall, complying with the laws and regulations relevant to holding and accounting for the assets, B, keep the assets separately from the personal or firm assets. So there should be a demarcation between the client's assets and your personal or firm's assets. C, use of assets only for the purpose for which they are intended. So there must be some understanding with your client that okay, these assets are with your possession to be used for such and such purposes. So these assets are only for the purposes for which they are intended. So they must be used for that purpose only. Be ready at all times to account for the assets and any income, dividend, gains generated to any individual entitled to that accounting. So there are basically 4 conditions wherein you are holding money or other assets belonging to others. Number 1, comply with the law and regulation for holding such assets. Assets should be kept differently, distinguishedly, and use the assets only for the purpose for which it was intended, and always be ready to discuss the detail or share the account regarding income, dividend, gain generated to any individual entitled to that accounting. What is engagement period, audit and review? What is engagement period for audit and review? The engagement period starts when the audit team begins to perform the audit. Engagement period starts when the audit team begins to perform the audit. The engagement period ends when the audit report is issued. So engagement period starts when the audit team begins to perform. And when does it ends? When the audit report is issued. When the engagement of a recurring nature, it ends at the letter of the notification by either party that the professional relationship has ended, or the issuance of the final audit report, right? Where the audit client is statutory audit client under Company Act 13, the engagement period shall be determined in accordance with the provisions contained in the Company Act 2013. So it has to be followed for ascertaining this engagement period. If this engagement period for audit and review is not strictly followed, it means that is a professional misconduct. What is the meaning of indirect financial interest? Financial interest, indirect financial interest. So what is the meaning of indirect financial interest of SCA in practice? Indirect financial interest means financial interest beneficially owned through a collective investment vehicles, state, trust, or other intermediary over which the individual or entity has no control or ability to influence the investment decision. So because it is not a direct financial interest, so indirect, the question being, what is the meaning of indirect financial interest? Indirect financial interest means financial interest beneficially owned through a collective investment, means not directly, a collective investment vehicle which may be state or which may be a trust or other intermediary over which the individual or entity, individual means here chartered accountant, say for example, or any other entity, its firm, has no control or ability to influence investment decisions. So that is indirect financial interest. Whether a member not in practice means maybe in service, maybe in business, whether a member not in practice can use any other description, the answer is member not in practice may use, as per the provisions of section 7 of the CA Act, the designation chartered accountant. However, if he chooses to use the designation of chartered accountant, he shall not use any other description, whether in addition or in substitution thereof. However, such a member is not prohibited from adding any other description or letters to his name, if entitled thereto, to indicate membership of such other institutes of accountancy, whether in India or elsewhere, as may be recognized in this behalf by the council, or any other qualification that he may possess. I'm just repeating this answer once again. Whether a member not in practice can use any other description. Member not in practice may use the word chartered accountant. If he chooses the word chartered accountant, shall not use any other description, whether in addition or in substitution thereof. Such a member is not prohibited in adding other description or letters to his name, if entitled thereto, to indicate membership of such other institutions of accountancy also. So this is the basic law about using. Whether member in practice can list themselves with online application based services provider aggregators. Whether members in practice can list themselves with online application based service provider aggregator. No, cannot do. Council guideline advertisement appearing in volume 2 of code prohibits members in practice to list themselves with online application based service provider aggregators, wherein other categories like businessmen, technicians, maintenance workers, event organization, etc. are also listed. So in the recently we have found that so many platforms or apps came up in which some of our professional friends, chartered accountant friends have joined, but a clarificatory note was issued under the Code of Ethics 2020. Therein, the members were not entitled and they have to get themselves unregistered or deregistered or detached with those aggregator service provider. So members are not entitled to do that. Can a chartered accountant practice share his fees with the government in respect of government audit? Very peculiar question. CA in practice share his fees with the government regarding what? Regarding the government audit. Means I am doing the government audit and I have to share my fees to with the government. Can a chartered accountant do that? The institute came across certain circular order issued by the registrar of various state cooperative societies, wherein it has been mentioned that certain amount of audit fees is payable to the concerned state government, and the auditor has to deposit a percentage of his audit fees in the state treasury by a prescribed challan within a prescribed time of the receipt of audit fees. In view of the above, the council considered the issue, and while noting that the government is asking auditors to deposit such percentage of their audit fees for recovering the administrative and other expenses. Mind here, it is particularly mentioned that government is asking auditors to deposit such percentage of their audit fees for recovering the administrative and other expenses incurred in the process. The council decided that as such there is no bar in the Code of Ethics to accept such assignment, wherein a percentage of professional fees is deducted by the government to meet the administrative and other expenditure. So the meaning thereby that a chartered accountant in practice can share his fees with the government in respect of government audit when it pertains to the administrative and other expenses. So friends, thank you. This was my presentation on ethical issues, frequently asked questions on ethical issues. And time is up, and I hand over this to this organizer. Thank you, sir.
Thank you, sir. We have some questions that came up, sir, and if it is not addressed on those 100 questions which you have put up, we'll take it up, sir. Is my screen visible? I've just shared my Excel sheet. So we have some 4 to 5 questions. So if possible, you can take it up, sir.
So, okay, I'm taking up the questions. A CA can get jobs from another chartered accountant, but my question is that whether a CA can get a job from CPA from USA or CA from UK. any chartered accountant is free to join any organization. He can get a job from CPA from USA or CA from UK, right? Second question is, can the previous auditor ask the new auditor to show the letters of offer from the client in response to a letter of intimation sent to him by the new auditor? No. Previous auditor cannot ask the new auditor. Just NOC can be asked for. That's all. 3. What's the view of the virtual or part-time CFO? What is the view on virtual or part-time CFO? Can we take fees as sweat equity ESOP? Can CA buy shares as investment in client's business, assuming engagement is not an auditor? Taking one by one part. First part is that what's the view on virtual or part-time CFO? If you are virtual or part-time CFO, if your major time and involvement is towards that particular organization, then both the things cannot be carried simultaneously. But as a professional, if you are a insolvency resolution professional, that is permitted. But being part-time CFO or virtual CFO, you are more or less engaged in majority of the time with the organization. So in my view, that should simultaneously should not go with. Can we take fees as sweat equity ESOP? Can we take fees as sweat equity and ESOP? Sweat equity and ESOP is for the purpose of employees specifically, to motivate them to get attachment with the organization. But it is not for the auditor. Once the auditor is holding shares in whatever form, equities in whatever form, there is some interest is creating and contradiction of interest is there. So sweat equity ESOP by the auditor should not be accepted. It is mainly for the purpose of employees. Okay. Third part is, can CA buy shares as investment in client's business, assuming engagement is not an auditor? If you are not an auditor of that organization, and you are giving just consultancy services, then it's all right. But you are a auditor by whatever nomenclature or whatever services you are providing as auditor, you should not buy the shares, irrespective whether it is investment or trading. Can a member in practice as observer, examiner of other professional institute like ICMA, ICSI, etc.? Is it to be communicated to ICAI? No, it is generally permitted. This sister concern permission is there. 5. Can a senior partner in a CA firm restrict himself in just guiding, advising other partners, staff without signing, attesting, actively involving in audit, tax? Yes, senior partner is always free, because this is a important part and of guiding, advising other partners, because in somewhere, in some forms, we will find that who is the partner who is guiding or training the partner, training the staff's articles and all. So that is required to be mentioned here, that arrangement can be done. Answer for 5 is yes. 6 is, international auditing standard permit review of predecessor audit working papers. Is there any effort to include this in Indian standards? Till date, it is not on the paper, but if the time permits in the times to come, it may be included herein. But to my knowledge, at present, it is not here in Indian context. Question number 7. Practicing CA intended to go for employment. If the employer put a condition that I should surrender COP, in that case, if come back from employment in future, will my previous experience will taken into to become FCA? So certainly the day you surrender COP, there is a break in your continuity, but that period should also be taken into consideration while calculating. Suppose I'm today FCA, and I am joining some other organization as employment, surrendered my COP. So in that case, my FCA will be continuing, not that my FCA status will be lost. That is not there. So taking corollary from that, if you are breaking your practice for the time being, rejoin in practice, so that experience will count taken together. Our remaining partners of CA firm do have unlimited liability for an act of one partner of the compensation damages claimed by the client. Remaining partners in a CA firm to have unlimited liability. Remaining partners in a CA firm, unlimited liability for an act of one partner for the compensation damages claimed by the client. Friends, if this act done illegally or immorally or violation of certain law, then that particular partner is liable. But if any act done in the course of his practice, in the course of normal circumstances, in my view, under the unlimited liability, all the partnership firm and the partners are liable for the compensation and damages claimed by the client. Willfully misconduct, willfully violation of law, the partner who is conducting that will solely be liable for that. Question number 9, what are the benefits of holding part-time COP and how will regulation of ethics be involved? Whether we have to follow ethical guidelines for CA in service or CA in practice, please clarify. Friends, earlier there was a concept of part-time CP. Holding part-time COP has no use as such nowadays because you cannot sign any documents. You cannot, and most of these impanelments also, part-time COP holders are not recognized as such. So benefits of holding part-time COP are almost nil, where only the head counts are taken into consideration. For that purpose only, part-time COP is considered, otherwise not. And as regard the following of this ethical guidelines, so it is always compulsory for all of them. A different set of ethics has been prescribed for CA in service, and separate set of this ethical are prescribed for CA in practice. That is clearly there. Friend, if you go through this code of ethics, you will find, and as well as Chartered Accountant Act along with code of ethics, regulations and guidance note thereon, you will find that ethical guidelines for CA in service is different and CA in practice is different, and there are certain ethical guidelines that is to be followed by both, that is common for both. And one set is for, repeating again, one set for CA in service, one set for CA in practice, and one set for CA both, whether practice or service or any other. Can an auditor take assignment as statutory auditor, tax auditor of the client of which his wife is an employee? Client of which wife is an employee? No, cannot. In my view, cannot accept the assignment. So question 10 is over. Mr. Sundarajan, any other question?
So those were the questions.
Yes, sir. Yes, sir. Thank you, sir. Thank you for your wonderful presentation, sir. I hope the members are all enlightened by your presentation. and your clarifications.
The list
You
of
are
questions,
also happy, I suppose.
the list of questions enlightened me and encouraged me to see that good number of questions are pouring in. It means that people took interest in my session. And the best thing is
Definitely.
that around 500 members were throughout the session who joined this seminar. So that's a good number. I congratulate SIRC, the chairman, the organizer, the secretary for organizing such a nice session, sir. And all the members, above all the members who have interestingly participated in this workshop seminar. And basically the style of presentation which I myself has evolved, made it evolve, that if this sort of pattern is followed, so at least 100 common questions are clarified to all the members. And you must have noticed that these are the common questions which are being raised by members off and on. And this is on the basis of my experience only that I have selected these 100 questions. Thank you, sir.
Thank you, sir. Thank you so much, sir. On behalf of the SIRC, the chairman and the team, and on behalf of the members who participated in this program, I thank you so much, Mr. Hariram Agarwal, sir. It has been so encouraging for both your clarification and the members' participation is so encouraging, and so we all thank you for that. Thanks, sir. Nice talking to you, sir. Thank you, sir. Bye.
Thank you, sir. Thank you all. Thank you, and thank you all. Thank you, Chairman, sir.
Yes, sir. I'll tell him, sir. Thank you, sir.